I'm going to be talking to you about consumers' cancellation rights. Quite a number of consumers that you deal with will have cancellation rights under the Consumer Contracts Information, Cancellation and Additional Charges Regulations of 2013, and hopefully by the end of the session you'll have a clearer picture of when clients do have the right to cancel and how to deal with it. The regulations have been around for quite some time, been around since June of 2014, so for a couple of years, so you need to be well aware of it because failure to comply can be quite expensive. So, they apply to off-premises contracts. Any contract that you agreed with a seller or landlord off-premises will mean they're getting cancellation rights if they're a consumer. Off-premises contracts are quite extensive, and we'll talk about those in the next few slides, but it isn't as simple as you think it might be. So remember that landlords are consumers unless they're definitely businesses. So you must be giving your landlords that cancellation right if it applies. Doesn't apply to tenancy agreements. Tenancy agreements are exempt under the regulations, so it won't apply if you have a tenant signing a contract off premises. If it is an off-premises contract with a consumer, then written information about those rights has got to be provided to the client in the statutory format. If it isn't, you're in breach of the regulations. The cooling off period that they have is now 14 days. Some of you might remember that initially it was 7 days. From 2008 to 2014, clients had 7 days cooling off period. Now we have 14 due to these new European regulations. As I've said, failure to provide written information is an offence, and it means the cooling off period then extends from 2 weeks to 12 months and 2 weeks, so to 54 weeks. So it's very important that you give people their written cancellation rights at the time you sign the contract, because if you don't, they can cancel at any time, no matter what work you've done for them, no matter how far down the selling process or the rental process they've got, and you've got, you can't charge them anything at all. They would be entitled to cancel at any time. So making sure it's there is very important. In theory, you can't market the property for 14 days unless the client gives you written instructions to market within that 14-day period. We'll talk about how you do that in a second. If you do market without the client's instructions within that 14-day period, then it is at your risk, at your cost. If they cancel, you can't charge them a single penny because they didn't give you instructions to market within that cancellation period. So, what are the benefits of getting your client to give you written instructions to immediately market? Well, the first thing is that you avoid losing instructions, because if you have to wait 2 weeks to begin marketing, then one of your competition may well step in there and take your instructions, and they might start immediately marketing. So you don't want that. You don't want to lose the instructions. You want to get it on the market. The second thing, and as important, is gives you the opportunity to advise your client that you will charge them reasonable costs and expenses should they exercise their right to cancel. So they told you to immediately market the property on the day they instructed you. Therefore, they can still cancel, but if they do, you will be able to charge them reasonable costs and expenses that you've incurred from the point of instruction through to the point of cancellation. So therefore, if they realise they're going to have a cost if they cancel, then that is going to dissuade them from cancelling. However, remember that if you work on a no sale, no fee basis, this is definitely not going to be possible for you, because it would be a contradiction in terms. As soon as you say there is no sale, no fee, then that has to be the case. Now let's talk about off-premises contracts. Off-premises contracts fall into three categories. One agreed whilst you're in each other's presence, so you and the consumer client are in each other's presence and you're not in your office. That would be a fairly typical valuation situation. You go to the house, you do the valuation, the client says get it on the market, you say yes, that's great, we will. We'll start marketing it this afternoon. That's a typical off-premises contract, and one where the client then gets a cancellation right. Fairly straightforward, that one. The second one is where you and the client are together in each other's presence. You're not in your branch office. The client says to you, put it on the market, but you don't agree that you're going to put it on the market. You say something like, well, no, we can't agree to put it on the market at the moment. We need to get the paperwork sorted out. We need to get the terms of business signed, etc. So could you call into our office the following day? We'll get the paperwork signed. We'll get everything in place and we'll market the property. That used to be a way around giving people a cancellation right. It's not anymore. We've filled that hole in. If the client says put it on the market while you're in their home, they get a cancellation right, even if you don't agree to put it on the market until later on. So they filled that one. And the third one is you do your valuation. They don't instruct you immediately to market the property. They say something like, we've got another agent coming round later on. The other agent comes round later on and they don't like them, so they then immediately ring you up or email you and say, hey, we didn't like the other agent, you're the best one, please put it on the market. So they get a cancellation right under these new regulations. So it's very clear. It doesn't matter that the contract's agreed in the branch, it's actually whether they came back to you immediately after your visit to tell you that they wanted the property put on the market. Now, the definition of immediately is something that the courts will have to decide. They've not decided at the moment. My view is, if they're coming back to you within a couple of hours, even within the same day, you might say, hey, we really need to leave this, we need to class this as a cancelable contract and provide the written documentation that they require. Now, the written documentation is quite involved. You have to give them clear written instructions about their cancellation rights. If you are going to immediately market the property, then you have to give them a signature box that will say, please immediately market my property. Then you have to tell them exactly what will happen if they cancel within that cooling off period. So you want us to immediately market. If you cancel, you will have to pay our reasonable costs and expenses. And if we do find the buyer for you, then you will have to pay our full fee, even though you decided to cancel. But we found you the buyer, so therefore you will have to pay us our full fee. And the final thing you will need is a cancellation rights notice. That will be something that the consumer can fill in and send back to you to say, hey, I want to cancel my contract. So these premises are quite complex and quite a lot more involved than agents do believe, and so you have to get it right, because if you get it wrong, then your contract is unenforceable. Trading standards can take action against you, and there's a maximum £5,000 fine for every contract you enter into where you don't give your client those cancellation rights. So you must make sure that you get it right. If you need any more information on cancellation rights, then you can visit our website, which is www.compliance-matters.co.uk. Thanks very much for your attention, and I hope you found it useful.